Thank you. So as a brief introduction, this event is being hosted by the UBC, the brand new inaugural UBC Centre for Migration Studies. Please feel free to follow the center at UBC Migration on Twitter. The Twitter handle is also up on the PowerPoint slide for your reference. I'd like to thank the organizers of this event, Emily, Atier, and Doug, without whom this couldn't have come together so easily. I'd also like to acknowledge that we as students, as professors, as faculty, as staff at UBC are fortunate to gather today on the traditional, ancestral, and unceded territory of the Musqueam people. I'd like to review the question and answer procedure before we begin. After Professors Kaushal and Hastie give their talk, there will be an opportunity for attendees to pose any questions or make any comments they may have. You can use either the chat function at the bottom of your screen or the raised hand function. Any questions that are sent in through the chat function, I'd be happy to read to Professors Hastie and Kaushal if you're not comfortable asking the question yourself. However, feel free to use the raise hand question if you'd like to engage directly. I'd now like to introduce our speakers. Let me turn to my notes. Professor Asha Kaushal teaches and researches in the areas of immigration law, constitutional law, and legal theory. Professor Bethany Hastie, her research lies at the intersecting space of labor and employment, migration, and human rights law. We are fortunate to have these two professors with us today. I will now turn the proverbial mic over to Professors Kaushal and Hastie. Thank you.
Thank you very much, Molly, for that introduction. So just to dive straight in, it'll be familiar territory to cover in March 2020. At the start of the COVID-19 pandemic in Canada, the world seemed stricken by this specter of closure, of immobility. But not long after, as time rolled on, the manner in which mobility was being stratified became as interesting as the manner in which it was being curtailed. For example, questions like who was allowed in, what was the substance and evolution of the restrictions and their exceptions, and most significantly, what could be learned about immigration regulation by putting those measures into temporal perspective, looking at past, present, and potential future forms that border regulation assumed, were questions that were at the forefront of our minds and consistent preoccupations. And these questions ended up forming the basis of our examination into the federal government's efforts to border the pandemic through the lens of legal response to emergency. And so our talk today is based on the substance and outcome of a collaboration we engaged in throughout the summer and with JD graduate Devin Eag, and which resulted in an article that's now forthcoming with the National Journal of Constitutional Law. So in our time today, I'll first discuss some of the factual background of COVID-19 and Canada's border response. And Asha will then discuss the legal context in which this response was undertaken as reliant on orders in Counsel and in the context of this idea of emergency. We'll use that as a backdrop to then discuss the implications that might flow from this response. So Asha will first discuss the consequences of regulating through orders in Counsel, and I'll then take up a discussion of the potential discriminatory impact of the regulations under Canadian immigration law, and how this may be working towards a reigniting of the significance of status, both at and within our borders. So turning to the next slide, Canada's border response to COVID-19 unfolded in two key phases. First, an early phase where the federal government introduced measures tailored to regional COVID-19 outbreaks. And second, with blanket measures restricting entry into our country. Canada's first presumptive case of COVID-19 was discovered in Toronto on January 25th, 2020. Soon thereafter, the government began organizing repatriation efforts for residents and citizens from China and issued its first order under the Quarantine Act requiring all persons repatriated to undergo a 14-day quarantine upon arrival. The Canadian Border Services Agency also began enhanced screening at airports for travelers arriving from affected regions. Orders on February 17th and 19th expanded the mandatory 14-day quarantine order to individuals arriving to Canada from any country experiencing a COVID-19 outbreak. And then by March 7th, the global number of COVID-19 cases had surpassed 100,000. Days later, the WHO shifted its characterization of COVID-19 virus from an epidemic to a pandemic, triggering emergency measures across the globe. And at this point, the second phase of the Canadian government's response followed. So on March 18th, the Canadian government issued its first emergency order banning the entry of non-citizens and non-permanent residents into Canada. Specifically, this order prohibited all foreign nationals from entering Canada by air, with exceptions for immediate family members of Canadian citizens or permanent residents, status Indians, protected persons, essential service workers, and foreign nationals who had remained in Canada or the United States in the previous 14 days. Further orders on March 20th and 22nd restricted all non-essential travel from the United States and travel from all other foreign countries, respectively. In tandem with these orders, the federal government imposed a mandatory 14-day isolation or quarantine order, which applied to everyone entering the country regardless of their immigration status. So turning to the next slide, this table illustrates two primary categories that the IOCs or orders in council were used to regulate the border during COVID-19. And the categories are those statuses that were exempt from border closure measures and therefore permitted to enter Canada, and those statuses that were excluded and prohibited from entering Canada. Now, while the pre-COVID-19 mobility regime, global mobility regime, was hardly one of cosmopolitan free movement, these measures have marked an abrupt departure from a system predicated on facilitating many forms of travel. Canada's public health orders have dramatically pared down what Kantian scholars call the right of hospitality, which comprises the right to temporarily visit foreign states and the right of asylum. Rather, these orders have largely cordoned entry rights around those with permanent status in Canada and others whose presence offers some utility to the nation in the context of this crisis, notably international students and workers. Even business visitors have not been spared. Only business visitors from the United States who can demonstrate that they are entering for a non-optional purpose are permitted entry, a standard that leaves significant discretion in the hands of immigration officers and much room for uncertainty. In short, though, under the federal government's emergency orders in council, Canada's immigration and border system is far less open than it was pre-COVID. And while I'll later discuss how these orders have impacted various categories of migrants in and to Canada, first I'll turn it over to Asha to discuss the legal context of orders in council and governing through law in an emergency.
Thank you, Bethany. So what I want to start with is just the idea of what an order in council is, and then I'll talk a bit about emergency, and then I'll talk about orders in councils in the context of emergencies. So orders in council are a legal instrument. They're an executive branch instrument. You've probably heard in the United States of executive orders, similar but different. I'll talk about why it's important that it comes from the executive branch later. They are passed, orders and councils are passed under existing pieces of legislation or existing statutes, and they happen quite quickly. And so this makes them very attractive for governing during an emergency or a crisis. You can put the order in council, you can have it up and running in a matter of a day or two. And so I'll talk about the procedure for that later too. One aspect to keep in mind here, and many of you will know this, is that orders in council, the way that they're rolling out now, are not happening under the Emergencies Act. And so there was a lot of speculation in the beginning that the government would invoke the Emergencies Act, and that would have triggered a whole number of different regulatory measures and safeguards. The government opted not to do that, instead proceeding under these orders in council, primarily under the Quarantine Act, and Bethany has alluded to that a little bit. The boiled down version of that is that the government is governing an emergency without emergency oversight or without the safeguards that you would find if indeed the Emergencies Act had been invoked. So all of the major orders in council, all of the border closures or closures plus exceptions, and Bethany has also talked about some of these, and she'll explore them more later. All of those happened under orders in council. And so there was this moment where people went looking for how was the border closed in this way. And that's where they're all online, and that's where the closure happened. The general critique, and I'll talk about this a bit more, but the general critique of orders in council is that they lack the scrutiny that any other kind of regulatory measure might receive, whether we're talking about regulations or legislation or maybe something else. In this case, because the orders in council are quite far-reaching, and to some extent they establish new categories and new statuses, and certainly new exceptions, often premised on this idea of who is essential, we want to look carefully at the how, right? How is the border closure happening? How are the exceptions being promulgated? And this means that we have to look quite closely at the OiCs. Bethany will circle back to this, but it's worth keeping in mind at this point that historically, OiCs have been used a lot in immigration regulation. And in the days when plain discrimination was acceptable, so 50 years ago or more, certainly at the time of Confederation, orders in council often preceded legislation, and they often contained this sort of raw purpose, this raw discriminatory purpose of some kind of border measure. And so we want to be cognizant of that. We want to be aware of that as we think about the work that they're doing here. Okay, so let me talk a little bit about the idea or the theory of emergency. The theory of emergency is important in law. There's quite a lot of scholarship about the nature and the reach of emergency powers. A quote about this is that in a time of emergency, most states turn quickly to law. Certainly that's true of liberal democracies. And I will speak shortly about our last example of a border closure in a context of emergency, which was 9/11. And it's the quintessential example of this kind of emergency, right? In that scholarship or that literature, there's this distinction between ex ante constraints, so framework statutes like our Emergencies Act that might constrain government powers at the outset, and ex post constraints. So in law, we call this judicial review, or the court reviewing measures that the government has taken after the fact to decide whether those are in accordance with law or not. In the context of COVID, we don't have either because we haven't invoked the Emergencies Act, and we don't yet have judicial review decisions. Enough time has not rolled out, nor do we know whether there will be. It's a different context, and it's hard to know what might get reviewed or not. So the key concern of this scholarship is to consider how emergency powers might be, how we might keep emergency powers from being abused, right? So different scholars will focus on different locations for curtailing this kind of abuse. Some focus on the judiciary, some focus on the executive, others focus on the legislature. But they're all concerned with this idea of legality. So what do I mean by legality, or what do they mean by legality? They mean using the law to constrain the way that the state governs through law. So when the state governs an emergency, having the law act as a constraint on that kind of governing. Sometimes that's referred to as the rule of law. The rule of law has also a very specific meaning that I don't want to get into here, but I'll try to use the term legality to capture something a little broader. Some of us will know in migration studies Giorgio Agamben and the state of exception. And you can find Agamben's sort of theoretical predecessor here too in emergencies, right? So Carl Schmitt was a fascist theorist in Germany. And all of this emergency theory at some point references Carl Schmitt and the idea that he put forward about where the law is in the context of an emergency. The short version of what he suggested was that law has no place in an emergency. So when a state enters what is called a state of exception, or what we will refer to here as an emergency, then the sovereign or the state acts with political will during that state of affairs or during that period of time. So political will is what governs, and the law recedes into the background. That state is purely political, which means that the law can't constrain what the government does during that time. So this is the source of trouble, or this is troubling for legal theorists, because the aim or the goal is to have the law constrain governance during an emergency to make sure that state powers are not abused. And so a lot of the scholarship focuses on to what extent liberal democracies suspend or pause law in order to take these kinds of self-preservation measures in a time of crisis or emergency. So in the paper, we talk about a professor at the University of Toronto, Professor David Deisenhouse, who has done a lot of work on emergencies in the context of 9/11. And one of the concepts that he uses to think this through is the concept of legal black holes, which have a certain resonance in the 9/11 context that they might not hear, but are helpful for us to think about what we call the stickiness of emergency orders or situations. So the things that might endure and why we need to be concerned about them. So legal black holes are situations where, in which individuals who are suspected of being threats to national security are detained indefinitely, for example, right? And so this happened a lot, obviously, during 9/11. Some examples are obviously Guantanamo Bay and national security certificates that are buried in the IRPA, and there are other examples as well. What is new, or what he remarked on as being new at that time, was that the emergency had no foreseeable end. And so it was in some sense permanent. And so it was doubly important to make sure that the emergency was governed by law to some extent, at least. And this sort of has two pieces in Professor Deisenhouse's theory. The first is the concern that the government will procure for itself exceptional powers during an emergency. So the executive and or the legislature will govern either directly through things like OiCs or potentially through legislation. And I'll talk about that in a moment. And then the second piece of it, or the second phase, is that then the judiciary will review those measures and treat them as unencroachable, or support them, uphold them. And so his argument is more absolutist than some of the other theorists working in the area, people like Bruce Ackerman and Cass Sunstein and Oren Gross, who agree that there should be some rule for law in an emergency, but they accept breaches of legality. So they say in some context, the law must recede, this must be pure political will. And Professor Deisenhouse contests that. So what I'd like to talk about now, I'd like to introduce this idea of stickiness a little bit more in depth. And then I want to talk a bit about 9/11 before we think about relating this to COVID-19. So stickiness for us is the idea of the afterlife of the emergency laws. So what might endure or what might stick, right? To use a sort of more colloquial understanding of it. So how can an emergency context, including its laws, fundamentally shift the form and the content of legal regulation over the longer horizon, so over a period of time? So one part of this is sort of it tracks a similar two-piece kind of analysis. One part is that the emergency measures or the orders might calcify. There might be a calcification of either the orders themselves or the kinds of statuses or exceptions that they contain, right? So the content of those orders might achieve some kind of traction over the longer term. The second piece of it is that they might be accompanied, or those measures and their calcification might be accompanied by a sense of reasonableness and necessity. so that lawyers and society alike look at the new statuses and the new exceptions and think the world is different now, and these are required even if they are exclusionary or they raise legality concerns or other types of concerns. So Professor Deisenhouse talked about this in the context of 9/11, and he was concerned with the judiciary, and he used a concept of seepage. To some extent, we build this idea of stickiness off of that idea of seepage, the idea that it starts to seem reasonable and regular, and they endure for that reason, right? Okay, so let me talk a little bit about what we might think of as the emergency precursor to COVID-19, which is 9/11, the last instance of a border closure close to what we have now. Now, there's some things about 9/11 that are obviously very different, some aspects. There are also some aspects that are parallel. 9/11 was not only, but maybe primarily about ex post constraints and judicial review. So a lot of the concern about 9/11 and the scholarship about it was about how this idea of seepage had taken hold. And so there were indefinite detention was at issue, Guantanamo Bay was at issue, habeas corpus, or the right to bring yourself before a court if you've been detained indefinitely was at issue. So that's different from where we are, like I said, because we don't have in the COVID context judicial review yet, right? We don't even know if that's on the horizon. I mentioned how 9/11 had generated legal black holes, and I talked about those a bit. I'm just going to try to do two things at once here. So there are these differences between what happened in 9/11 and what seems to be happening now in during the pandemic, but they did both trigger global responses. They did both trigger exceptional legal acts and measures, and they both resulted in the closure and the narrowing of the border. And so those are the pieces that we want to pull on a bit today to see what we can draw from them. So this was a key part of 9/11, right? Especially at the beginning, and later less about closure of the border and more about a really tightly regulated and controlled border for some people and some things. And so border control is this key part of the 9/11 response, along with its corollary, immigration law, and it sort of takes different forms in both places. The border obviously plays, again, a huge role during the pandemic, right? You can think of both the foreign nationals coming from international destinations coming into Canada, but perhaps most pertinently for lots of us, the closure of the US-Canada border, which is renewed on a monthly basis or so, and which is the site of a border closure, obviously, but also a very robust set of exceptions. And Bethany will talk about some of those. Neither 9/11 nor COVID-19 rested on a declaration of emergency under the Emergencies Act, so that's something else that's similar about them. The way that the border initially closed under 9/11 was that the White House issued a level 1 customs alert, and that essentially sealed the US-Canada border. And many of you, it's on the slide there, maybe have heard stories about the lines of trucks at the border, truckers sleeping in their vehicles while they waited to see if they could cross. Entry was on an ad hoc basis. Agents were fully inspecting everything. There were flights diverted to Canada right away. So there was this sort of initial closure that mirrored what happened in COVID-19. And then that obviously parlayed into slightly different kinds of border measures. After that initial level 1 customs alert, there were all kinds of agreements that followed from that. So there was the Smart Border Declaration, there was the Safe Third Country Agreement about refugees, there was the Beyond the Border Framework, and then most recently in the USMCA, we've had those programs, some of those programs built into that free trade agreement. So you have trusted travelers and you have trusted trader streams, you have customs pre-clearance. So what comes out of that in the 9/11 context is a thickened border. And so one way to understand that thickening and this is something we try to articulate in the paper, is that there is this omnipresent risk assessment, which is about those enhanced border measures, but it's in the service of keeping the border open and flowing. So on the one side, you have passports and biometrics, and you can only bring small shampoo bottles and all kinds of measures like that. And then on the other hand, you have fast track security lines, you have cargo pre-screening, you have measures that ensure streaming, right? In terms of legislation, you have, by the end of 2001, you have an Anti-Terrorism Act that greatly expanded state powers over terrorism. Some of those powers, like police powers, were so robust that they were subject to sunsets, 5-year sunset clauses, after which they expired. They did expire, and then they were reenacted in 2013 through the Combating Terrorism Act. So there were pieces of the 9/11 response as it rolled out that evolved into regulatory measures or legislation. And there was also the use of existing measures, things like security certificates, which have been in the Immigration Refugee Protection Act for a long time, that were used in new or different ways, right? In the COVID context, legislative measures thus far have been primarily about economic measures. They've been about economic relief, but we don't know what happens over the longer term. What we want to take away from the 9/11 example, we want to take away a few things, but I guess at this point, what I would say, one thing we want to take away is this segregation of commercial and non-commercial traffic and this kind of streaming at the border, and how that grounds the types of border restrictions that are essential. And so you've heard a lot in COVID-19 about keeping supply chains open. Maybe you've heard about the essential non-discretionary entry exception, and Bethany will talk a little bit about that. And so those are ways of making sure that the border can be crossed, that there are exceptions inside the orders in council that close the border. Okay, I know I've been talking for a long time, but I do just want to put this idea of emergency and what we've learned from 9/11 into the context of OiCs themselves. So I want to talk a little bit more about the details of them. I don't want to go too far down a rabbit hole because they can be quite dry. It's quite procedural how they the different ways that they can roll out, but it's important for us to think about the choice to go under orders in council and the Quarantine Act, along with a few other legislative acts, versus proceeding another way. So the orders in council regime in general raises some of those same concerns about legality that we saw with respect to 9/11 and that we saw with respect to theories of emergency, albeit in this context with respect to the executive and not the judiciary, right? And the reason for that is because of what orders in council are and how easily they are passed. So let's talk about these a bit. The features of orders in council. So they're emergency powers. They're not always emergency powers. You can issue orders in council for other things as well, often routine measures. Here they're being used in the context of an emergency, passed by the executive branch and its delegates. And so orders in council, in brief, things that they avoid, let's say. So they skirt parliamentary procedures for review. They skirt lots of procedures for debate or openings for debate. They skirt committee study, and they skirt the voting on these kinds of measures. And I'll talk about those aspects a little bit more. So why are we concerned about this, or why do we take you through sort of these details about orders in council? Because if one is going to govern an emergency outside of a declaration of emergency, then there are questions raised about the sufficiency of democratic oversight and questions about legality. And so we want to be attuned to those while we think about this mode of regulation, right? Okay, so like I said, this is a fine balance between making sure that we all understand orders in council and not going too far down a rabbit hole of procedure. So There are regulatory instruments and there are non-regulatory instruments. Regulatory instruments are things like regulations. So for those of you that work in migration, you know about the Immigration and Refugee Protection Act. You know it's quite a big act. You know its regulations are even bigger, right? Regulations are subject to things like executive examination, approval, registration, publication in the Canada Gazette. Non-regulatory instruments, in contrast, sometimes about routine matters and other times not, are subject to much fewer kinds of, or many fewer kinds of review. So they're typically sent to the Department of Justice and then sent to the Privy Council for approval. Maybe the Treasury Board will review them if they're non-routine matters. Okay, so the point I want to make, and having asked you to sit through this, this discussion of OiCs, is that the enabling legislation or the legislation the government chooses to govern under can matter a lot for the review procedures of the way it governs, right? So here what I want to do is contrast the Emergencies Act, which we are not operating under, and the Quarantine Act, which is under which the orders in council we are talking about have been promulgated. Just very briefly. So the Emergencies Act requires a two-step process. First, the government would declare an emergency, and then it would begin issuing emergency orders. All of those orders would have to be based on reasonable grounds. They require consultation with the provinces. They're time limited to 90 days. They can be extended, but written reasons are required in Parliament. Those orders and regulations are presented to each House of Parliament. There's further review by a parliamentary review committee. Typically, if the emergency is continued, then the Governor and Council reviews all of those orders and regulations. And then at the end of the emergency, because by definition, emergencies are supposed to be temporary, the Governor and Council prepares an inquiry. So that is layering oversight on top of what we call the Statutory Instruments Act, or what is called the Statutory Instruments Act. It's additive, and it's ensuring that any declaration of emergency and governance under it is subject to quite a bit of oversight. On the other hand, if a government chooses to proceed under the Quarantine Act, there aren't any procedural prerequisites, so there isn't this requirement to declare an emergency. Orders made under the authority of the Quarantine Act are not regulations or deemed not to be regulations, which means they're not subject to the Statutory Instruments Act review procedure that I talked about with respect to those regulations, generally under IRPA and otherwise. Orders have to be published in the Gazette and they're tabled in Parliament within 15 days, but there isn't a provision for special review. So I hope that we can take away from that the sense that a declaration of emergency and the orders under the Emergency Act that would follow are much more robustly checked and safeguarded and reviewed than the orders in council that might be made under, for example, the Quarantine Act. And it is under the Quarantine Act that the biggest orders in council were passed. So the March 20th and 22nd travel restrictions, for example, the quarantine requirement, and so on. So why did the government proceed this way? There are many possible reasons, and we don't spend much time speculating on them, but it could be linked to the minority government status. It could be linked to the role for the provinces and federalism concerns about governing an emergency top down. It could be linked to a real concern about how temporary this pandemic was and how difficult it might be to govern and pass orders in council or emergency orders under a different regime. And so with that in hand, I want to now turn it back to Bethany to talk a bit about what's inside those orders in council and why we maybe need to pay close attention to them.
Thanks, Asha. And so as Asha discussed, right, OiCs and the use of them are, as a legal instrument, are exceptional because they largely operate without the scrutiny given to ordinary legislation. And in the context of the government's response to COVID-19, they're also exceptional because they are operating outside of the applicability of these ex-ante constraints that would otherwise exist in regulating in the context of an emergency, right? If this was happening under the Emergencies Act. Moreover, as she discussed, the potential stickiness that attends temporary responses to emergency situations. In other words, the idea that these temporary and exceptional measures can in fact become lasting and permanent features, in this case of Canada's immigration system, invites a consideration then, right, of how these IOCs might produce lasting changes for Canada's immigration system and what those might look like. And so in our remaining time, what I want to discuss is how the OiCs might be working towards reigniting the significance of status in immigration law, both within and at the border, as well as how historical uses of OiCs in immigration law in Canada in particular, as Asha alluded to, were done for plainly discriminatory purposes, and why we therefore ought to bear this in mind in thinking about the potential for discrimination to unfold in the current and future contexts. So first, the OiCs have already changed the significance of status at the border. And here I want to talk briefly about two examples from our paper. First is the way that family status is defined at the border, and the second is in respect of treatment of refugee claimants. So first, foreign nationals who are immediate family members of Canadian citizens or permanent residents are exempt from travel restrictions, as that earlier table illustrated. And immediate family members may be authorized to enter Canada from a third country for family reunification purposes at the discretion of an immigration officer. Now, what is somewhat different is that this category has been defined distinctly in the current context as including a spouse and common law partner, dependent children or grandchildren, parents or step-parents, and guardians or tutors. But this excludes conjugal partners, couples who have been in a marriage-like relationship for at least 1 year, but do not cohabit. It also excludes most adult children and grandparents. And so the term immediate family member and the particular grouping of relationships it represents is a new configuration in Canadian immigration law. And it works to heighten the significance of close attachment to a resident or citizen of Canada as a basis for entry. And so in the paper, we argue that this already represents a departure or new instantiation of the way in which status is understood and applied to regulate entry under the orders in Counsel, and that this could therefore, right, have lasting change moving forward in how we think about these categories and statuses. Second, as long as they remain in effect, the orders in Counsel have superseded Canada's international legal obligation not to turn away refugee claimants without hearing their claims. Foreign nationals are currently prohibited under the OiCs from entering Canada from the United States, including for the purpose of making a claim for refugee protection, with limited exceptions. So the OiC prohibitions also apply between official ports of entry along the land border, and so more broadly than previous legislation, thereby closing off areas of access for refugees. Now, in the paper, we talk a little bit more about how this intersects with the Safe Third Country Agreement that Canada has with the US, but the short conclusion is that in general, these restrictions contravene Canada's international obligations. And a legal opinion issued in March by the UN High Commissioner for Refugees emphasized the illegality of these kinds of blanket restrictions under international law, which have also been criticized by many international human rights organizations like Amnesty International. So these OiCs, right, being passed and being used to regulate absent the kind of oversight and scrutiny that typically accompanies law in Canada, are now also being used to supersede international obligations and arguably to facilitate or allow for what would otherwise be characterized as illegal conduct. And again, without democratic oversight, without legal oversight. So second, and turning to the next slide, we should also be wary about the use of OiCs to regulate immigration and create further status-based distinctions in light of the use of this particular legal instrument in historical immigration contexts in Canada. This brief history provides reasons that we should be cautious about the use of OiCs in immigration law today and the new socio-legal dimensions of discrimination and precarity that they may introduce. So prior to the development of Canada's immigration law system in the 1950s, OiCs were a common instrument for implementing immigration policy. The historical use of OiCs to exclude and contain Asian immigrant populations in particular was a prevalent feature of immigration policy in Canada in the first half of the 20th century. A well-known example is the 1908 OiC that imposed a continuous journey requirement or rule, which prohibited immigrants from entering Canada unless they arrived by a single continuous journey from their country of origin. Now, at the time, steamships that carried immigrants from India and Japan notably frequently made stops in Hawaii before landing in continental North America, effectively prohibiting those would-be immigrants from landing in Canada under this OiC. Perhaps most infamously, this OiC was used to turn back the Komagata Maru, which is the picture that you see the ship on the slide, which landed in Vancouver in 1914 after sailing from China with 376 Indian nationals aboard. The ship spent about 2 months in the harbor before returning to India following a failed legal challenge at the BC Supreme Court. Now, throughout the 1920s and 30s, we saw further use of OiCs to exclude groups of immigrants, particularly, again, immigrants from Asia. For example, in 1923, an OiC was issued to exclude Asian immigrants except agriculturalists, farm laborers, female domestic services, and the wife and children of a person legally in Canada. This OiC preceded the Chinese Immigration Act by only 5 months, illustrating how OiCs can become the basis for lasting legal change. And that act, for the duration that it was in force until the late 1940s, severely curtailed immigration from China. So by regulating the border through status-based distinctions, the COVID-19 border restrictions are tied to Canada's long history of status-based immigration policies, the discriminatory implications of which raise concern for today's context as well. The abandonment of an explicitly racial and national discrimination policy and immigration law in the 1960s means that a return to overtly discriminatory measures like those I just reviewed is unlikely, but the history highlights the concern that regulating the border through status-based distinctions today may permit status to function as a proxy for racial discrimination. And indeed, in many other areas of both scholarship, law, policy, and research, we do see heightened concerns raised about the use of citizenship status as a proxy for racial discrimination, both within Canada and many other jurisdictions. And so contemporary legal measures that appear non-discriminatory on their face may nonetheless prove discriminatory in effect. And this is not only because of the nature of the immigration categories themselves, which sometimes prefer, for example, certain states or countries of origin and their nationals for certain types of work, but also because of the socio-legal landscape that immigrants encounter upon arrival. And so then turning to the next slide, and to the third point about the significance of status within our borders. The content of the laws addressing the COVID-19 emergency demonstrate in many ways that the boundaries of belonging and of protection run along the axis of status much more than the axis of location. This marks a resignificance of status inside and not only at the border. And so here I'll talk in particular about the example of temporary foreign workers in Canada. So the OIC framework set up mobility exceptions for essential workers, including temporary foreign workers. Again, as the earlier table had illustrated, essential workers and workers with a valid work permit are exempt from the border restrictions, or in other words, they are permitted entry into Canada. And this is primarily to address economic and food supply chain concerns when we look especially at the entry of temporary foreign workers in Canada. So like other exempt categories, this enables temporary foreign workers to continue arriving to Canada despite the current border restrictions and OIC regulations. However, while the OIC framework facilitates their entry into Canada, once inside, many temporary foreign workers have faced significantly compromised living and working conditions. So within the border, the OICs and the measures to respond to COVID-19 illustrate the ways in which status-based distinctions may result in differential treatment, again, giving further way to further concerns about discrimination and racism. And this is illustrated most readily by the different and delayed policies pertaining to migrant farm workers in Canada. So when farm workers were first permitted renewed entry to Canada after the border closure in March, no guidelines existed to advise employers of their obligations regarding quarantine and other public health measures. In the intervening weeks before these guidelines were developed, and after the period at which farm workers continued to enter Canada, there were, as a result, COVID-19 outbreaks experienced on several farms. Now, when the guidelines were eventually developed, they also contained notable differences from the public health advisories for permanent Canadians, residents, and citizens. In particular, migrant farm workers could still be housed together and could work during their quarantine period. And finally, despite widespread concern about whether these measures were being followed by employers and on farms, little proactive enforcement and inspection has been reported to date. And more recent research and evidence has suggested that there remains significant problems in the implementation of the limited guidelines and policies that do apply in this context. And so the OICs may have permitted entry for these farm workers, but their status proved overwhelming once inside the border, where until very recently, the government evaded its obligation to extend public health measures to farms. And again, even after formal extension, we continue to see notable obstacles in practice. And so to sum things up very shortly, the pandemic has encouraged emergency governance through OICs. And as we've discussed today, OICs exist to regulate without the scrutiny that attaches either to legislation or to measures that are undertaken where an emergency is declared. Those OICs operate through status-based distinctions that we argue have rearranged hierarchies of belonging and of protection in Canadian immigration law, both at and within the border, and which may have enduring discriminatory effects into the future, particularly with respect to vulnerable populations. So that concludes the presentation, and we're really looking forward to your comments and questions. Thank you.